attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the first Lawcast in a series discussing Rule 506 of Regulation D, including the difference between the traditional 506B offering and a 506C offering that allows general solicitation and advertising. As a precursor, I will discuss the importance of industry events such as the upcoming Rodman & Renshaw Global Investment Conference. Effective September 23, 2013, the SEC enacted Rule 506C, resulting in the elimination of the prohibition against general solicitation and advertising in private offerings in which investments are strictly limited to accredited investors. Trailblazers such as RealtyMogul.com, CircleUp.com, WeFunder.com, and SeedInvest.com proved that the model can work, and the rest of the capital marketplace has taken notice. Recently, more established broker-dealers have begun their foray into the 506C marketplace with accredited investor-only crowdfunding websites accompanied by marketing and solicitation to draw investors. The historical Rule 506C was renumbered to 506B, and issuers have the option of completing offerings under either Rule 506B or 506C. Rule 506B allows offers and sales to an unlimited number of accredited investors and up to 35 unaccredited investors, provided, however, that if any unaccredited investors are included in the offering, certain delineated disclosures, including an audited balance sheet and financial statements, are required to be provided to all potential investors. Rule 506B prohibits the use of any general solicitation or advertising associated with the offering. SEC interpretations and case law have established the principle that where there is a pre-existing substantive relationship with the offerees, offers will not be considered to be made by general solicitation. Recently, the SEC updated guidance on the questions surrounding the establishment of a pre-existing substantive relationship with offerees. As part of its guidance, the SEC discussed presentations at conference and venture fairs. Participation in a conference or venture fair does not automatically constitute general solicitation or advertising under Regulation D. Obviously, if a company's presentation does not involve the offer or discussion of securities at all, no solicitation is involved. Though realistically, the vast majority of companies that participate in these conferences are doing so to raise capital. If the attendees of the event are limited to persons with whom either the company or the event organizer have a pre-existing substantive relationship, or have contacted through a pre-screened group of accredited, sophisticated investors, such as an angel group, a presentation will not be deemed to be a general solicitation. However, if invitations to the event are sent out via general solicitation to individuals and groups with no established relationship and no pre-screening as to accreditation, any presentation following the offer of securities would be deemed to involve a general solicitation under Regulation D. So, for instance, the upcoming annual Rodman & Renshaw Global Investment Conference is scheduled to be held from September 8th through the 10th in New York City. More than 200 public companies from around the globe are expected to present to an audience of more than 2,000 attendees. Similarly, the National Investment Banking Association, i.e. NIBA, will have its next conference in New York, October 12th to the 14th. These events are not mass advertised, other than to past attendees, and attendees are required to confirm accreditation at the time of purchasing tickets. Arguably, a presentation at one of these conferences would not involve a general solicitation. Conferences are a great way for companies to present themselves to a large group of potential investors, investment bankers, and industry types. Most such conferences include corporate presentations and Q&A sessions, one-on-one side meetings, and a general opportunity to meet and interact with each other. Although significant industry developments proliferate rapidly via electronic communication, there are a large amount of subtext that can only be learned by actually putting boots on the ground. In the age of the internet, it is essential for professionals to get together in a productive atmosphere, shake hands, and have direct human interaction so as to work together more efficiently. Regardless of the cutting-edge communication platforms we so often rely upon, nothing can replace the human experience. Sometimes it is not what presenters or industry experts say in their presentation that spark the next great sector, but more so the tone of the experts and attendees can be the more accurate barometer of what is happening in the industry overall. In an era where information, communication, and connecting with the new OTC industry professionals is more important than ever, conferences such as the upcoming Rodman and Renshaw and NEBA events are becoming increasingly essential. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com. Inquiries of a technical nature are always encouraged.